Welcome to the Deep Dive. Today, we're tackling a really interesting situation, something coming out of Utah.
Yeah, it involves a citation, a $1,000 one, given to a man named Michael Troy Richardson.
And it was for, well, simply identifying himself as an engineer. Seems straightforward, but it's definitely not.
Exactly. And to really get a handle on this, we've looked at a few things. We have Richardson's profile from the Association for Challenge Course Technology, that's ACCT, gives us some background.
Yeah.
Then there are two key documents for the legal side. One called Utah Engineer Hearing Unconstitutional.
Right.
And another one that lays out the Utah hearing key points, sort of the cliff notes for the hearing arguments.
So our mission here is to, really unpack these sources. We want to understand the core issues.
Yeah, get past the headline, look at the legal stuff, the different sides.
And what it all means for professional titles, free speech, and, importantly, public safety.
There are definitely some surprising twists here. Should be interesting.
Okay, let's dive in. Where do we start? Utah's definition.
Let's start right there. The crux of the issue. How Utah defines engineer.
Okay.
According to that Utah Engineer Hearing Unconstitutional document, the state basically says engineer means you have a professional engineer license, a PE.
And getting that involves specific steps.
Oh, yeah. Pretty rigorous. You need to pass the FE exam Fundamentals of Engineering, then get 4 years of work experience supervised by a licensed PE.
Okay, 4 years.
And then you have to pass the PE exam itself. So it's a high bar. It's like many professions with licenses, right? Designed to ensure competence.
Makes sense. So who is Michael Richardson in this picture? What's his background?
Well, his ACCT profile calls him an engineer at a company called Momentum Engineering.
Momentum Engineering. Okay.
And the hearing documents add more context. He has a Bachelor of Science in Engineering Technology. Importantly, it's from Utah Tech University, and it's ABET accredited.
ABET accreditation. That's usually a sign of a solid program.
It is. And he also has experience in technical writing, specifically dealing with safety recommendations.
Okay, so he's got the degree, the experience. What's the problem then?
Well, this is where the friction happens. Richardson's main argument, laid out in those hearing documents, is that Utah's definition is just too narrow.
Too restrictive.
Yeah. He thinks it's unconstitutional, actually, that it infringes on his right to describe himself accurately based on his education.
So he's saying, I have this degree, I should be able to use the term.
Essentially, his point is that using engineer, especially with an engineering technology background, shouldn't automatically mean you're claiming to be a PE.
Ah, because the path to a PE license might be different or maybe not even available for engineering technology grads compared to, say, civil or mechanical engineers.
Exactly. That's part of his argument. It's not always a direct path.
And this all started with that $1,000 citation.
That's the trigger. A $1,000 fine under Utah Code 58-1502. It's for unlawful conduct.
Unlawful conduct. And that links to another law.
Seems like it. Probably 581501(1)A. That part prohibits practicing or even just representing yourself as qualified to practice a licensed profession if you don't have the license.
So the state's logic is he called himself an engineer, therefore he was implying he's a licensed professional engineer.
That appears to be the state's position, yeah.
Okay, so why does Utah care so much? Why this strict definition?
Good question. That document we have, the one outlining arguments for the citation, it gives us clues. It mentions DOPL.
That's the Division of Occupational and Professional Licensing.
Right. Their main justification is almost certainly public safety.
Protecting the public.
Exactly. They'd argue that limiting the engineer title to licensed PES protects people from unqualified individuals doing work that could, have serious safety consequences.
Like designing a bridge or a building's electrical system. You want someone who's met specific standards.
Precisely. You want verified qualifications for critical stuff.
Makes sense. Anything else?
They're likely also worried about the public being misled.
How so?
They might argue that Richardson calling himself an engineer and his company being Momentum Engineering could make people think he's a licensed PE, even if he isn't.
Ah, that idea of holding oneself out as a professional.
Exactly. It's a key legal concept. It's not just the word itself, but the impression it creates. Does it imply a level of licensed authority, especially in a business name?
So it's this tension, the state trying to regulate and protect, and Richardson saying, hey, this is my education, my profession.
That's the core conflict, and Richardson isn't just taking it, he's fighting back.
Based on what? What's his defense strategy?
Well, those hearing documents, Utah Engineer Hearing Unconstitutional and the key points, lay it out. A big piece is the First Amendment. freedom of speech.
Free speech. How does that apply?
He argues his use of engineer is commercial speech. It relates to his business and profession.
Okay.
And the government can regulate commercial speech, but those regulations can't be overly broad or restrict truthful information unnecessarily. He's saying Utah's definition is too broad.
So his argument is, my degree is in engineering technology. Calling myself an engineer based on that is truthful, not deceptive. Why is Utah stopping me?
That's a big part of it. He's also bringing up the 14th Amendment.
Due process and equal protection.
Right. He might argue the law is vague. Like, is it really clear that someone with his specific degree can't use the term engineer at all? Does the law give fair notice?
Yeah. Is it clear enough?
And he might also question if enforcing it against him specifically has a rational basis under equal protection.
And he's also emphasizing the difference between just engineer and professional engineer, right?
Absolutely. That's key. He's likely arguing that, common usage is different. Lots of people with engineering degrees aren't PEs, but are still called engineers in their jobs.
Like software engineers, for example, though that's a whole other debate.
Right. And he might argue his work, like the technical writing, isn't actually the kind of work that legally requires a PE license, the stuff like signing off on plans.
And he's willing to use a different title.
He's indicated willingness, yeah. Titles like engineering technologist. He seems open to clarification, just not a complete ban on using terms related to his education.
What's this about the Plain Language Act he mentioned? That's interesting.
Yeah, the 2010 Act. His argument there is that Utah's definition of engineer isn't actually clear or easy to understand for the average person.
Leading to confusion.
Or potentially arbitrary enforcement like he feels happened to him. He's basically saying the law itself is poorly written.
And finally, he's arguing this citation harms him.
Unjustly, he'd say. It limits his ability to accurately talk about his skills, his education, his experience. Hurts his professional standing.
This feels like it can't be the first time this has come up. Have other states dealt with this?
They have. And the documents mention a couple of key cases that could be relevant precedents.
Oh, like what?
One is Jarlstrom versus the Oregon Board of Examiners.
Jarlstrom, Oregon.
What happened there? This was a guy had a Bachelor of Science in Engineering. He got fined for calling himself an engineer in some emails he sent about, of all things, traffic light timing.
Seriously? Traffic lights?
Yep. He argued it violated his First Amendment rights. The Institute for Justice actually backed his lawsuit.
So another case of someone with an engineering degree getting fined for using the title.
Exactly. The suit challenged Oregon's attempt to restrict the title solely to licensed PEs as unconstitutional free speech restriction. Very similar argument.
Any others?
There's also Wayne Nutt versus the North Carolina Board of Examiners.
Okay, Nutt in North Carolina.
He was a retired engineer. The board told him he couldn't offer opinions on engineering matters anymore without a current license.
Even just offering opinions.
Right. But a federal judge sided with Nutt, again, citing the First Amendment. The judge emphasized people should generally be free to talk about their expertise.
Wow. So these cases suggest courts are sometimes pushing back against really strict state controls on the term engineer.
It seems that way. These cases are important for you to understand because they directly challenge state power on First Amendment grounds, arguing the restrictions were just too broad.
And does Utah have examples it could follow? Better ways to handle this?
Well, the Utah Hearing Key Points document actually points to California and Nevada as potential models.
California and Nevada, what do they do differently?
Apparently, their laws make a clearer distinction between licensed PEs and people in other engineering roles.
Okay.
They might, for instance, allow businesses doing engineering work to use disclaimers if they don't have licensed PEs. Just be clear about it.
That sounds reasonable.
Yeah.
A way to balance things. Allow people to describe their skills, but ensure the public knows who's licensed for certain tasks.
It could be a path forward. It addresses the core constitutional concerns in Richardson's case, which, as the key points emphasize, really circle back to that First Amendment free speech issue and the 14th Amendment due process concerns.
The vagueness and broadness arguments again.
Exactly. Is the law clear, and is it being applied fairly without punishing speech unnecessarily?
Let's get specific about the Utah laws involved here. You mentioned the code sections earlier.
Right. So the citation itself likely falls under Utah Code 58-1502. That section covers unlawful and unprofessional conduct and its penalties.
And that's where the potential $1,000 fine comes from.
Yes, it states that violating the unlawful conduct rules is a Class A misdemeanor and can carry administrative fines up to $1,000. So that matches Richardson's citation. It's a pretty broad statute covering various licensed professions.
And what counts as unlawful conduct specifically?
That's defined in the previous section, 581501, and the key part for this case is subsection 1A.
Which is?
It defines unlawful conduct as practicing or crucially representing oneself as qualified to practice a licensed profession without the license.
Ah, the representation part again.
That's almost certainly DOPL's hook. They likely argue that by using the title engineer, Richardson was representing that he could do the work requiring a PE license.
Even if his actual work was different.
Potentially, yes. The statute also mentions unprofessional conduct, things like breaking rules or practicing beyond your scope. So DOPL's argument probably hinges on interpreting Richardson's title use as implying he was a licensed PE.
So when you hear about this, it really makes you think, doesn't it? Have you ever paused to consider what professional titles mean in your own job or industry?
Yeah, how clear are those lines? Where does one role end and another begin?
This Utah case really throws a spotlight on how specific words and regulations can have major real-world impacts on people's careers.
Absolutely. The idea that just using a term tied to your degree could lead to a fine, it definitely raises big questions about how we talk about our skills and our knowledge. It's something you might relate to in your own professional life.
Definitely food for thought.
So at the end of the day, this deep dive into Michael Richardson's situation highlights that fundamental tension, doesn't it?
Balancing professional standards and public safety.
Against an individual's right to accurately describe what they know and what they do.
So summing up, what are the main things to take away here?
Well, first, engineer doesn't mean the same thing everywhere. Legal definitions vary state by state. That's critical.
Okay.
Second, those cases in Oregon and North Carolina, they suggest courts are increasingly scrutinizing very broad restrictions on professional titles, especially if they bump up against free speech rights.
A potential trend to watch.
Could be. And third, what happens with Richardson's hearing in Utah? The outcome could set a precedent for how engineering technologists and others with similar backgrounds can describe themselves moving forward.
Right. It could have ripple effects.
Definitely.
And it leaves us with a final thought to chew on, maybe.
I think so. In this world where everything's getting more specialized, how do we make sure regulations protect the public effectively?
Without accidentally stifling innovation or preventing people from accurately describing their diverse skills. It's tricky.
And what's the individual's responsibility in all this? How clearly do we need to state our specific qualifications?
Yeah. This whole situation, starting with just one word engineer, really shows how even simple language can become a battleground for some pretty significant legal and constitutional debates.
It certainly does. A lot packed into one title.